Brynhan da a croeso. Good afternoon, everyone, and thank you so much for joining us for this Will Writing webinar today, which we are hosting in conjunction with Geldards. My name is Sarah Morgan-Davis, and I am the Legacy and Development Officer in DIVA. It's my pleasure to welcome you today. So a little bit of housekeeping. The session is being recorded and will be available on the Cardiff University YouTube channel after the event. And this will be sent to you along with some other information in a post-event email. The Q&A function will be up and running as soon as Laura's presentation begins. So please feel free to use that and ask any questions. Thanks so much to everyone who submitted questions in advance. There were loads, which is amazing. I know Laura's tried to answer as many of them as possible within the presentation, but I'm hoping we'll have a little bit of time at the end of the session to answer any additional queries. So it's now my pleasure to introduce to you Cardiff graduate Laura Aiken. Laura is an associate solicitor at Geldards, and she specialises in providing advice in relation to wills, lasting powers of attorney, trusts, tax, and estate planning. Thank you, Laura.
Thank you, Sarah, for the introduction. I'm just going to start to share my screen with my slides, and then we can get going. There we go. I hope everyone can see that. So, prynawn da, good afternoon. Diolch yn fawr am ddod. Thank you very much for spending your time listening to me. So, as Sarah said, today I'll be talking about wills, why you need one, different types of wills, inheritance tax, and some other useful things for you to think about. So I hope you enjoy and I hope you find it useful. Just to give you some background, Geldards are one of the UK's leading law firms. We have offices in Cardiff, London, Derby and Nottingham. We're really well established. We've been in the Cardiff area for years and years now. And we provide a really broad range of advice to a variety of clients, mainly, well, private, public and third sector. So we work for a lot of charities, we do commercial work, and also obviously private clients and individuals as well. And as Sarah said, I'm an associate in the private client team, and this is my area of specialism. So to start with, why do we need to make a will? What do you need to think about? So a will is basically the only way to give you peace of mind and to make sure that the people that you want to benefit from your estate are benefiting in the best way. Without a will, the intestacy rules apply, and you may be leaving behind a legal headache, a practical headache, possibly an unnecessary inheritance tax bill, and very likely an unnecessary legal fees bill as well. Even if you do have a will, it's really important to review it regularly, as this just makes sure that it's keeping up to date with any changes in legislation and changes in your personal life as well. Busting some myths, so some common points that I often hear as to why someone hasn't made a will or doesn't want to make a will are that I'm married, so my spouse will receive everything anyway. We've been together for years, so we're common law husband and wife, or I live with my partner, but I'm not really sure I'm ready for serious commitment as making a will. In all of these scenarios, you still need a will. None of those are true. So the only way that you can ensure what you want to happen is to put it in a will. And just to cover the rules of intestacy briefly. So the rules of intestacy are set up by the government, and they govern what happens to your estate if you haven't left a will. So if there's a surviving spouse, but no children, then in that case, the spouse does receive everything. If there are children, personal possessions will pass to the spouse. The statutory legacy, which is currently £270,000, will pass to the spouse, the surviving spouse. And if you think in this day and age, that's not actually that much by the time you take into account perhaps the value of a property, which has increased in value. And then everything after that is divided in half. Half goes to the spouse, half of what's left. The other half is divided between the children. So you can end up in a situation where children, perhaps even young children, are part owners of a property with the surviving spouse, which can cause all sorts of practical difficulties. If there isn't a surviving spouse, this is the way that the estate will kind of trickle through the family, really, and it kind of goes down this list. So if there, as I said, no surviving spouse, it will go to children. If there are no children, it goes back up to parents. If there are no parents alive, it goes to siblings, half siblings, grandparents, uncles and aunts, and then right at the end of the list is the government. So even if you think, I don't really have anything, or I don't have close family that I want to benefit, it's still actually quite important to do a will, to kind of give control to someone to deal with your estate, to name an executor, and also depends on how you feel about the government ending up with your assets. You might prefer it to go to a charity or to friends, and you can control that through a will. So it's really important to note, if you are cohabiting and have a partner but are not married, your partner, your cohabitee, has no entitlement at all to your estate, even if you've been together for years and years and have lived together for years and years. If you live in a house together that perhaps only one of you owns, so if you were the house owner and you have a partner who's living with you, or vice versa, the partner who has no interest in the house doesn't have any control or any right to be able to stay there. If something happened to the property owner, their share of the house, or the house, would pass to their family, whether it's parents, children, siblings, and leaving the partner in the house with no control, being owned by the family members, and it just can be a very difficult situation. Even if you own a house together, so if you've got a partner and you live together and you own half each, the death of one person results in the partner co-owning the house with basically the deceased's family members. So it could mean that the parents own half of the person who's died along with the partner. And unfortunately, I don't think there's very many cases that I've seen where that ends particularly happily. It's a very difficult situation. The only route then for the surviving partner to be provided for is to bring a claim against the estate of the deceased person. So that's basically the partner suing or bringing this claim and saying, well, I should have received something through the courts, and it's upsetting, it's costly, and it's just not a very nice position to be in. There are some assets that pass completely outside of the will and completely outside of an intestacy situation. So assets that are owned jointly, such as a house that's owned as joint tenants, joint bank accounts, joint savings accounts, they will automatically pass to the surviving co-owner, whether that's your spouse, your partner, children, whoever co-owns the asset with you, it will automatically pass to them. Which some people might think, well, that's great and that makes it easy, but it's just important to take into account, is that actually what you want to happen? Or would someone perhaps want to give some money to charity or give some money to a family member? And then the other assets, the other things that pass outside of the will, outside of the control of the will, are most pensions, provided that you've made sure that you have an up-to-date expression of wish, naming the beneficiaries that you wish to benefit from your pension. Death in service benefit is the same, that will pass outside of the estate, provided you've got an expression of wish as to who you want to benefit, and life insurance policies. Another benefit of those three things, pensions, death in service, and life insurance, is that with an expression of wish, it passes outside of your estate for inheritance tax as well. So it's quite a useful way of mitigating or minimizing an inheritance tax bill. So I've mentioned inheritance tax, and I think lots of people are concerned or interested or want to know about inheritance tax. So I thought it'd be helpful to give a brief overview of the current inheritance tax position and what the allowances are. So every individual has a nil rate band of £325,000. So that's an amount that you can leave free of tax before any inheritance tax kicks in. Everything over that £325,000 is technically will be taxed at 40%. However, there are some exceptions and allowances which can increase how much you can leave tax-free. A few years ago, the government introduced what's known as the residence nil rate band, and that's an extra allowance. It's currently £175,000 per person, or up to £175,000 per person. And that can be claimed provided certain criteria are met. And those criteria are that you have a property or you have owned a property, that you are passing it down to your direct descendants, and that's a specific category of people, but it covers mainly children, grandchildren and stepchildren, and there's a few others in there, and that the value of your estate is under £2 million. If you satisfy that criteria, and a lot of people do, when you combine your £325,000 and up to £175,000, you can have a maximum of £500,000, so £500,000 per person that can be left before inheritance tax is paid. There is also a spousal exemption, so anything that you leave to your spouse, so whether that's £10,000 or £10 million, if you left that to your spouse on your death, then there shouldn't be any tax to pay at that point. And then on your spouse's death, they would claim their allowance of up to £500,000, and they could claim the unused, the first person's allowance as well, and they can roll that over. So between a couple, you should have £1 million that you can leave tax-free. Anything then above that £1 million is taxed at 40%. There is a charity exemption, so anything that you leave to charity is exempt from inheritance tax. There's also relief available for businesses and agricultural property. So that allows businesses and agricultural assets to kind of pass down generations without it being heavily taxed. And then there are lifetime gift allowances as well. So there's smaller amounts that people can leave, birthday, Christmas gifts, smaller gifts throughout the year that can be taken out of a tax bill. Every individual also has a £3,000 allowance to use, so that just means it gets taken off an estate before tax is applied. Anything above that £3,000 is what's known as we call it a PET, is a potentially exempt transfer, and that is subject to the 7-year rule. Lots of people are familiar with the 7-year rule. What it means is if you give a gift over that £3,000, so say you gave £100,000 to a child, if you died within 7 years of that gift, your estate would be treated as if you still had that £100,000 when calculating the tax bill. It doesn't mean that the £100,000 gets pulled back in, because your daughter probably would have spent it or used it, but so they still have the benefit. But in terms of tax, your estate is treated as if you still have that £100,000. If you survive for 7 years from the date of that gift, it falls out of your estate. And obviously that's only a concern really if your estate is above the relevant nil rate band that would apply to you. In terms of charitable gifts, just to expand a little bit on that, your will can act as a really good opportunity to think about who else outside of friends and family that you might want to benefit from your estate. And lots of people and lots of clients I find don't really think about it initially. It's something that once I mention prompts them to think, oh, actually, we do have this cause, or we do support that charity, and they then decide to leave a gift to them in the will. There are some quite big tax advantages to leaving money to a charitable organisation. And when I say charitable organisation, I don't just mean the really big, 100 million plus charities like Cancer Research and British Heart Foundation. It can be really local charities. It can be church, the NHS is a charitable arm, Cardiff University has a charitable section that you can leave money to, and lots of people do and give guidance as to how they want that money to be used, whether it's for research or to set up a scholarship, for example. Another benefit is, as I said, any bequest to charity completely exempt from inheritance tax. And if you leave enough of your estate, so it's 10% of the base value of the estate, which is quite a complicated calculation, but if you leave enough of your estate to charity, you actually have a reduction in inheritance tax that's paid. So it reduces the rate from 40% to 36%, which can actually make quite a big difference. And I've got some illustrations here. It's the best way to show it is in a very practical way. So if you have a look at this estate, it's Mr. and Mrs. Bale. No prizes for guessing where I got these names from. They've got an estate of 2 million, they're married, and they've got nil rate bands. They've each got £325,000 normal nil rate band and the extra £175,000 residence nil rate band. So the total amount that they can leave tax-free is £1 million. Their taxable estate then is £1 million, and tax at 40% of that is 400,000. So they would be facing a £400,000 tax bill. Second family is Mr. and Mrs. Ramsey, and they have an estate of 2 million, take away their nil rate bands of £1 million. Now they've decided to give £140,000 to charity. So that reduces the size of the estate that can be taxed to 860,000. And when you tax that at 40%, their estate is paying £344,000 of tax. And then the third example, Mr. and Mrs. Allen, their estate, again, 2 million. If you take away their nil rate band of £1 million, they are giving slightly more, £10,000 more to charity, which is 150,000. That brings the taxable estate to 850,000. And because they have satisfied that criteria that they're giving enough of a portion of their estate to charity, they're now being taxed at 36%. So they are paying £300,000 to charity. I think it's easier when you look at this table, just to see that in the first example, the family are getting 1.6 million once the tax is deducted, charity doesn't get anything. If you look at the second two, it's really interesting that the Ramsey situation, the family get a bit less, the charity get a bit more, the taxman gets a bit less, and total amount going to beneficiaries is about £50,000 more than Mr. and Mrs. Bale. But if you look at the Allen example, the family get a bit more, the charity get a bit more, the total that the beneficiary gets is almost £100,000 more than Mr. and Mrs. Bale, and they're paying £100,000 less in tax. So it's not to say everyone needs to do this, but it's a good exercise to do. If someone is leaving a gift or wants to leave a specific amount to charity, it's worth doing these calculations, because sometimes adding a little bit more of a gift to charity can bring the tax bill down quite significantly. There we go. So looking at preparing a will, what's stopping you? And these are lots of reasons that I hear very often from people or from clients. My circumstances are complicated, it's difficult to decide who I want to have and what I want them to have, and things are likely to change in the future. We can't decide who we want as guardians, is something that's at the bottom of the list. And then other concerns that are really valid that clients have are, I'm worried that my son, for example, will split from his wife, or I'm concerned my spouse will remarry and then the children won't have anything. I've got a business and one child works in it and the other one doesn't, so how do I make a fair distribution between them? I've got a beneficiary, whether it's a child or a grandchild with a disability, and I'm worried about how to approach that. Or, you know, if there's a significant inheritance, it's a concern about how children receive it and what they're going to do with it and how they spend it. All of these things can be solved with a will. So the will planning process, if you're coming to me and we'd sit down, these are the kind of things that we would talk about. So the starting point would be a fact find around the value of the estate and the makeup of the estate. And this picture is more to illustrate that I need to know about any kind of skeletons in the closet. It's not a completely inappropriate or morbid photo. But it's just to know if there are any surprises, or if there is something from years ago that perhaps you've forgotten about or no one knows about, or family member or child that, you know, perhaps the rest of the family don't know about. It's still really important that I know that to make sure that your wills work in the best way and in the way that you anticipate and you want them to work. We'll have a chat about your family, what your objectives are, any concerns that you have. We would talk through the kind of range of options, because it's not just one will fits all. We work on a very kind of, we tailor our advice to every client, so everyone has different needs and different concerns. So we'll talk about the different types of will you can do, and it's all about making an informed choice. I view my role as kind of giving the options, making you aware of the pros and cons and any pitfalls, and then you deciding what works best for you, and then obviously making sure the will is prepared, signed correctly so it's valid. Looking at wills, there are some different types to think about and different things to take into consideration. The starting point is usually doing a pretty straightforward will, which I would say would be leaving everything to either your spouse, your partner, your children, and keeping it quite straightforward. The benefit of this is that the estate would benefit from the transferable nil rate bands if you're married, and potentially the residence nil rate band, and it just keeps it quite nice and simple to deal with. However, there are things to be aware of and pitfalls to doing such a straightforward will. It leaves the entire estate vulnerable to the circumstances of the survivor. So if you have a concern about paying care fees, or the survivor of you remarrying or being taken advantage of financially, if you leave everything to them, the entire value of the estate is vulnerable to their circumstances. If you're unmarried, there are potentially some inheritance tax consequences of just keeping it really straightforward. Not really the best approach to have. If you've got quite a large estate, it does allow children to inherit potentially quite a large sum of money at a young age or at an inappropriate time. And it is potentially creating some inheritance tax bills going down the generations, which could quite easily be avoided or mitigated at least. So the way that we do that is to build in a bit more protection, and perhaps building a bit more control in the wills is to include a trust. So a trust is essentially, it's a way of making a gift with strings attached. It allows you to have some control and flexibility as to how your beneficiaries are provided for. And it gives them access to benefit from the assets that are held in the trust, but without it actually falling under their control. So there's different types of trusts that we look at when we're preparing a will, and these are the main types of trusts. So it's a life interest, discretionary trust, a disabled beneficiary, or nil rate band discretionary trust. Looking at life interest trusts, so these work really well. They work better for married couples just because of the tax treatment of them. And what they do is it ring fences a portion or share of the estate, so either a share of a property or share of cash, savings, investments on the death of the first person. so it's protected from the circumstances of the surviving spouse. So for example, the husband died first, his will would say, I leave my half of the house to my wife and perhaps any cash that I've got in my sole name, and my wife can carry on living in the property for the rest of her days. She can benefit from any income generated on the investments. But if she remarried, if she needed care, that money that's held in trust and that share of the property can't be taken into account. It's protected. So no matter what happens to the wife, and no matter what her circumstances are down the line, the husband's share is protected to eventually end up with the children or other family members, and it just allows a bit more control over what happens, and it allows probably a bit of peace of mind that something's going to the children no matter what happens to the wife, whether she needs care, whether she remarried. It's only her share and her money that's vulnerable. It works really well, this type of trust, for people in second marriages as well. So it allows a spouse or a person to provide for each other, whilst also protecting that a share to go down to each side of the family, so their respective children. So that's when I see clients who are in a second marriage, this is the type of information and advice that I would be giving them and urging them to think about seriously. Discretionary trusts. So a discretionary trust is a really good way to pass wealth on with strings attached, basically, so in a really flexible and controlled way. So rather giving the assets outright to the beneficiaries, so perhaps if you've got children or nieces and nephews and you've got quite a big estate, you might not want them to have all of that money, for a very practical point of view, to make sure that it lasts and it doesn't all get spent in one go. But also from a tax point of view, if you're passing a decent amount of money on to children and paying 40% tax on your death, and then you're inflating the value of their estates on their death, they would be paying 40%. A discretionary trust can kind of help manage those ongoing or generational tax bills. Discretionary trust gives a lot of flexibility. So if someone's got really complicated wishes that can't really be captured in a will, then the discretionary trust allows more flexibility in how we plan things. A discretionary trust is a good way, and it's the kind of way that I use to provide for a cohabitee or an unmarried partner, because in a lot of situations, it's not always ideal to just leave everything outright to an unmarried partner. So discretionary trust is a way to provide for them in a more tax efficient and practical way. We use discretionary trust where there are business assets and agricultural property assets to make sure that we get those inheritance tax reliefs that are available. And we also use a form of discretionary trust to provide for beneficiaries who are vulnerable or who are disabled. The key thing with a discretionary trust is that you have to prepare a letter of wishes to sit alongside the will, and this gives the trustees information and guidance as to how you want your assets to be used and who you want them to benefit. And then the key point is they're not legally binding, so it's really important that you pick trustees that you trust to act in line with your wishes, but also have a bit of discretion and a bit of sense to perhaps veer away from your wishes if they are not, if it's not a sensible decision. So with a discretionary trust, the really important part is picking the right trustees. That brings me to the end of wills. Before I finish, I also wanted to talk about powers of attorney because they are equally as important as a will. So a power of attorney is a document that you prepare to name someone or name people to be able to make decisions for you if you lose capacity to make those decisions yourself. So while a will obviously takes effect when you die, powers of attorney kick in and come into effect while you're alive, but perhaps you don't have capacity, you've lost your marbles, you don't have the ability to make a decision. And that's when your attorney would step in and be able to make decisions for you. There's two different types. There's one that covers property and financial decisions, and the other that covers health and care decisions. They do what they say. Property and finance deals with, dealing with a bank, paying bills, dealing with a property, dealing with utility companies, all very practical things. Health and care deals with where you live, treatment you receive, medical treatment, and there is a section in there on life-sustaining treatment. Without a power of attorney, it becomes very difficult for your family, even a spouse, to be able to make decisions for you. So even if you have a joint account, if one partner, one spouse loses capacity, the bank now these days are under quite tight regulation, and they will quite likely freeze at least a portion of the joint account, which can make life very difficult. The only way to be able to deal with someone's affairs if they lose capacity and they haven't got a power of attorney in place is to apply to the Court of Protection, and you apply for a deputyship order, and that's effectively a court-appointed attorney. The process to apply to the Court of Protection is long. It's upwards of 6 months. It's costly. You have to pay court fees, you have to pay application fees, and there's this ongoing reporting that you have to do annually and pay annual fees as well. So doing a power of attorney while you're able to is by far the better option. With the property and finance power of attorney especially, that would be really important, as I said, because without it, your family wouldn't be able to do anything. With health and care, it is slightly different, because obviously you will always receive care, you'll always receive treatment. Just without the power of attorney, the decisions would be made by doctors, nurses, social services, local authority, and they would have to act in your best interests. Okay, so power of attorney is a good way to give you a bit of peace of mind that your wishes will be followed and your family will be involved in making decisions. You don't necessarily need a solicitor to do them. There are some pitfalls and they can be quite fiddly, and there are ways that you can quite easily trip up, which can have an effect later down the line. So I would say it's always worth getting legal advice. But the forms are there, they're online, so you are able to have a look and do them yourselves. And I think that brings me to my conclusion. So just to summarize, don't put it off, make a will, or if you have one, review an existing one. I'd be more than happy if anyone wanted to get in touch with an existing will. We can do a quick review session just to run through it and see if it is, still does what you want it to do. It's always worth seeking specialist advice to tailor the will, and that it's to make sure it's structured in the most appropriate way, and to take into account any tax reliefs and any inheritance tax mitigation that can be done. And lastly, at the same time, while you're thinking about it, do a power of attorney as well. There we go. Thank you very much for listening to me.
Amazing. Thank you, Laura. That was incredible. I hope everybody got as much from that as I did. Really interesting and informative. We have got, as I mentioned earlier, quite a few questions. We're going to try and whip through as many as possible.
Yeah.
I'm really sorry if we don't get round to your question. Laura and Geldards have really kindly offered a free 30-minute phone consultation to all registered attendees. So this info will be included in your follow-up email, but thank you, Laura, for offering that. So I'm going to shoot straight in because we've got quite a few and I'm conscious of time. So I've got one. If you are the beneficiary and your parent doesn't leave enough to charity to benefit from the tax decrease, can you, as the beneficiary, top up the charity donation to access the lower tax rate?
There is a way of doing that. It wouldn't come so much from the beneficiary doing it themselves. The better way to do it would be by a deed of variation. And the important point with that, it has to be done within 2 years of someone's death.
Okay, thank you. Are off-the-shelf will writing packs as valid as the will drawn up by a solicitor? I already know the answer to
I
that.
mean, they can be valid. It's just obviously you're not getting the wider advice around pitfalls, inheritance tax, options in terms of, you know, as I talked about, putting a trust in the will. So I wouldn't say, I mean, I'm not a fan because we've seen so many cases where someone's done it and it hasn't been signed properly, it hasn't been dated, it hasn't been witnessed, and then it causes all sorts of confusion as to what, you know, what someone wanted versus the intestacy rules then kicking in. So I think some people think it saves money in the short term, but the longer term, it actually ends up costing a lot more money and trying to sort out a bit of a mess.
Yeah, so yeah, that's cool. Thank you. Can UK wills cover overseas properties as well as UK property and assets, or would you need a will in the country where your property was?
They can. The best option, so the gold standard, is to have a will in every country in which you own an asset. So especially if it's property. Bank accounts not so much because they are movable assets. If you have a property in Spain, France, or wherever else in the world, the best option is to have a will in that country, and it can deal specifically with the property you have there, because just in practical terms, if you die and your family need to get a grant of probate, getting a grant of probate in the UK, which then covers a foreign property, it just is a bit more difficult, and it has to then be notarized, and you don't know if it's recognized in the foreign country. So the easiest thing to do, even though it doesn't feel very easy at the time now, is to do a will in each country. But as a stopgap, and we do it, you can allow for your UK will to cover a foreign property.
I guess you just leave yourself open a little bit more, so having them in those relevant countries just covers it off. And yeah,
I mean, this is probably a whole other presentation, but there's different legal systems. A lot of the European countries don't recognise trusts, and if you use language in our wills, which we do because we are a trust-based legal system, it can cause some complications, and it's not guaranteed that what you actually want to happen will be followed in the country in which you own the asset.
okay.
So definitely worth having. I'm more than happy to have a chat with someone about it and go into a bit more detail.
Amazing. How do you deal with things like ensuring pets are taken care of as you wish if you die suddenly? Is there provision for this?
Yeah, you can put them in your will. Depends, it depends what you want to put in there. Lots of people, have cats and dogs who are part of the family, of course they are, and they put them in the will to say, I want whoever, family member or friend, to take care of any animals that I have. And then you can build on that, and some people like to leave money to the friend and family for taking them in. I do have a client who's very wealthy, who's basically set up a whole trust to look after their cats and dogs.
Oh.
So, it just depends what you want to do, but they can definitely be included.
Perfect. We've got somebody who's in a civil partnership and they want to know how they could protect their child's estate in case of their death, and then in case if their partner remarries. I know you covered off quite a bit of this in the presentation, but
that would be to include a trust. So it'd be a life interest trust, and that does exactly what that situation is. It allows someone to provide and protect their estate for their child, whilst also protecting and providing for your spouse or your civil partner, because you do actually have a legal responsibility to make suitable provision for a spouse or civil partner. So it balances those kind of requirements.
yeah. And how long does it take roughly to write a will? Fairly standard with a solicitor, would you say? Is it quite a swift process?
Yeah, I'd probably say if it needs to be done super quickly, it can be done within 2 to 3 weeks. The usual turnaround, because the process that I do is to either have either a sit-down face-to-face meeting or a video meeting where we'll talk through options and take some details, and then once we do all the kind of setup and confirm what we're doing and fees, etc., and then do a draft of the will and get someone to approve, the clients to approve it, and then come back in to sign it. Usually it's, 4 to 6 weeks.
Okay, so it's quite quick anyway then.
It is quick, and it can be quicker and it can be slower, but that,
Yeah.
I'd say that's pretty standard.
Standard. Can you make provisions for assets, for example, a house, to be held by a spouse until they die, and then the asset goes to a third party once they've passed on as well?
Yeah, that would be using a trust. So depending on the person's specific circumstances, that would govern which type of trust you use, but that can easily be achieved through using a trust.
Okay. And if somebody has any debts, would that be passed on to the next of kin? Or I guess that would be, how would that work, Laura?
So debts are taken out of or deducted from the value of the individual's estate. Mm-hmm. You don't pass a debt on, but it does eat in, obviously, to the value of the person's estate. So credit cards and that kind of debt would be paid off using the share of the deceased person, any money that they have. With a mortgage, it's a bit more complicated, but generally, when you're looking at the value of an estate, the debt gets taken away from the assets first when you're calculating what a person has.
Yeah. Okay, thank you. I think that's probably all we have time for. I'm just conscious of the time. So I know, sorry if we didn't get around to answer your question, but my advice is take advantage of that free 30 minutes, which Laura has kindly offered. So thank you so much to Laura and to Geldards for presenting today. And thank you all for joining us. At Cardiff University, we've been really lucky to have received some incredibly generous gifts in wills. And as a legacy officer, I'm in the really fortunate position of seeing firsthand just the incredible difference that this type of giving makes. These gifts are truly transformational. So some of the legacies that we've received have enabled us to do extraordinary things, such as helping students facing hardship, funding life-saving equipment, and actually several of our researchers are currently funded by legacies. So if you are in the position or thinking about including a gift in your will to charity, we would love for you to consider Cardiff University, and I'd love to have a conversation with you. Drop me an email, I can set up a meeting and we can chat through what this might look for you. Laura's already gone over what the benefits are in terms of inheritance tax, so great for charity, great for you, and it would be a pleasure to chat to you. But yeah, thank you again for today, Laura, and to everybody for attending. We will be hosting another one of these in the spring, so please feel free to join us then, and more details will be sent out to you. And have a lovely afternoon. Thank you, everybody.
Thank you.